Edward Prutschi, criminal defense lawyer, Adler, Batensky, Prutschi, and frequent contributor to the show, joins me. Edward, welcome.
Good morning, Jerry. Thanks.
So, guilty plea to first-degree murder. Now, that would lead us to believe then he's just going to cop to everything.
Well, I mean, that shows you once you've entered the pleas to the first-degree murder, and there were two, actually, first-degree murders that I believe he's entered pleas to, everything else is really ancillary. I mean, it fleshes out the story of what's happened here, and it may give some more comfort to the victims in terms of being very upfront, forthright, and fulsome, but the first-degree murders are it as far as everything else is concerned. I mean, those carry mandatory minimum life sentences and parole ineligibility for 25 years. So there isn't really any maneuvering or haggling or plea bargaining as one might expect under the circumstances. Those pleas basically indicate copying to everything, as you said.
All right. In the Sun today, in a comment on this, they make the comment that the second murder, a third, a fourth, whatever it is essentially free because the penalty attaches and there's no consecutive sentencing in this country.
Yes, I mean, there's truth to that. It's a bit sensationalistic to say that it's free. I mean, does it result in a longer sentence than life? No, it doesn't. But the reason for that is that there isn't a longer sentence than life. So when one looks at a 47-year-old going into custody on one first-degree murder or two or three or four first-degree murders, the end result is essentially the same. Colonel Williams is going to spend the remainder of his life in custody.
Well, or the remainder of most of it, because we don't know how long he'll live. But will this thing move along fairly quickly now because of the approach that he and his lawyers are taking?
Well, quite a number of days, if I understand correctly, have been set aside for the sentencing hearing itself. My understanding, and of course, news is coming out very sporadically, and I'm not at the hearing itself, but that I think 4 days have been set aside for the sentencing hearing. So, yes, that's going to be an awful lot quicker than had there been a preliminary inquiry, which was already waived, and obviously much quicker than if there were a trial. But it's not as if all of this is going to be wrapped up in a neat bow today.
Right.
And the rationale for that is not because the sentencing is particularly complicated at this point, because the reality is, with the life sentence being mandatory, it's not all that complicated. But I think what needs to be done and what everybody wants to see done is a detailed accounting of what exactly he's pleading guilty to, what the facts of this case are, in order to give closure and understanding not only to the public, but most importantly to the actual victims.
Well, then will all of the sensational material come out? He apparently videotaped these rapes and murders, and that seems like an additional hardship on the loved ones, but is it necessary for that to come out?
It's probably not necessary for that to come out, and my suspicion is that both defense and the Crown, in consultation on the Crown side with the victims' families, will have worked very carefully to determine an agreed statement of facts and an agreed format for the sentencing hearing to follow, so that the Crown will be able to introduce the evidence that it wants in order to flesh out the picture of the offenses, but will be respectful to the extent possible of the victims' families and what they do or do not want to be heard in court. So, I mean, it is a bit of a line that one has to tread across, because you don't want to minimize the offenses on the one hand, and you don't want to be burying things even though there is a plea here. The plea needs to be predicated upon actual facts that the judge is going to hear. But I doubt that you're going to actually see the horrific types of videos that may have been made.
Yeah.
Paul Bernardo.
Which I'm guessing had he adopted a not guilty plea and the necessity of a trial, we would have, and we'd have had a winter time of it.
Well, exactly. I mean, assuming that those things ultimately were found to be admissible, and that would have been one of the fights, no doubt, had a trial taken place, then they would have been played with certainty to a judge and ultimately to a jury. So one of the things that a trial avoids is having to re-victimize people, that the plea avoids is having to re-victimize the victims' families by making them see that kind of material.
Yeah. Edward Prutschi, criminal defense lawyer, Adler, Batensky, Prutschi. Thank you.
Thanks, Jerry.
Always good to talk to you.